Hello, this is Matt on the Moon Lambo channel. Well, the SEC did in fact file their appeal against the Judge Torres ruling in the SEC v. Ripple case, and so we have a number of answers, but we also frankly still have some questions here. It seems to me still highly probable that the SEC actually filed this Form C for appeal. It's called Form C. I think it's still highly probable that they did in fact file this a day late. But there's questions surrounding this. For one, the actual document that I'm going to show you is actually dated October 16th, yesterday, and if submitted yesterday, it's not late. But then, if you look at the electronic date that's on the document, which I'll also show you, that shows today's date. So which is it? And how could this even happen? Like, there are so many reasons that I'm like my head is just spinning trying to think through this. So bottom line on that, and I'll talk more about it, but we don't know for sure. It's my personal opinion that what is most likely, though I can't know for sure, but I think what's most likely is it was late. But and that is what most attorneys within the XRP community pretty much are. Well, so here's what I'd say. Pretty much every attorney, up until the moment the appeal was filed, had the same opinion that I'd seen anyway within our community, which is, yeah, it looks like this thing's late. It's late. And now there's an additional question mark after the filing actually came through. So again, we'll run through this all, and we do have some actual answers here, which I'm looking forward to share with you. For instance, XRP, they're definitely not attacking XRP itself. However, surprisingly, they are attacking Brad Garlinghouse and Chris Larson. Now, that one definitely surprised me because you may recall that the SEC dropped the charges against Brad Garlinghouse and Chris Larson. But now in the appeal, they're back. Weird stuff. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, as I record this video, it's 10:45 p.m. Central Time, so we got news of this, I guess, probably about 5 hours ago, so there's been sufficient time for people to react. Now, before showing you the very latest, I want to remind you of what the SEC told Fox Business journalist Alder just this morning before the filing came through. Because the deadline, it was last night. I don't think anybody's disputing that. The deadline was definitely last night, 11:59 p.m. Eastern Time on October 16th. And so that time came and went, and there was nothing online. There was nothing listed from the SEC. There was no Form C. And so everybody's scratching their heads. And I made a couple videos already to get everybody caught up to speed as best I can on this. But here's what the SEC said this morning. And here was the quote, because Alder was asking, hey, what's going on here? And this is the quote, verbatim from the SEC. The appeal is proceeding normally, and the documents will be filed publicly soon. Okay, so the Form C, who files Form C? It would be the SEC, correct? The SEC is the organization that would file Form C. Okay, right? That is correct. If that's not that, the logic I'm about to share with you isn't going to pass if that isn't true. But if the SEC is the organization that files Form C, then when the SEC itself says will be filed publicly soon, that means that they haven't filed it because there's only one filing that they're doing. They're filing it, and it's a public filing, right? Regardless of whether it takes half a second or a day. It's like, God forbid, there's a technical glitch and we actually have a full day delay in getting the document. From the SEC's perspective, if they're the ones that are filing this, then that's a public filing, right? And so they're saying the documents will be filed. If they will be filed, then they have not been filed. You see my logic here? The only way you could, and this sounds convoluted, and I don't see how this logically passes muster, but the only other way you could twist this is if you say the SEC filed the documents, oh yes, but then the courts themselves, they also filed the documents. Wait, so there's two filers of one document? And so it wouldn't make sense to me, because that's the only way this could make sense. If they still will be filed, then you could argue that the SEC, yes, indeed, did file them, but they also will be filed because the court has to file them too. That sounds ridiculous to me, though. But that's the only argument I could think of that would make this sentence make sense. That's the only one. Again, if the SEC, yes, they did file them, and so they truthfully said the documents will be filed publicly soon. They could only truthfully say that if it's considered to be true that the court also files them. But I've never heard of any lawyer articulate such a thing. I've only heard lawyers say, yeah, if you're the plaintiff, defendant, whatever it is, you file it. And then if it's for public consumption, that's a public filing. That's it. You don't then say the court filed it for them. So none of that makes sense. So if we take the SEC at face value, the sentence is on your screen verbatim, will be filed. That means they didn't file. If they hadn't filed, and that's as of August 17th, early in the morning, that means they didn't file by the deadline, which makes it extra weird because, as I'll show you in a second, that would mean that they must have backdated the document because the document shows October 16th, as if they magically filed it on time. So none of this makes sense. Shout out and credit to attorney James K. Filan for sharing this, and all sorts of other XRP community members did as well, but he's been really on top of this whole damn time. A very popular topic here. You can see this is posted 5:21 p.m. Central Time, which is my time zone. Already seen in, close to 5.5 hours. It's been seen 537,000 times. That's pretty wild. And it's been shared more than that from other people throughout the community. So I'm just saying it's pretty damn wild here. And so here's the actual form shared by attorney Filan. And you'll note at the top here, in the blue right here, the electronic filing date of October 17th. Now again, that's past the due date. But you go down here, let me scroll down further. It's dated, this is what the SEC put in, October 16th, 2024, which would mean that it's on time. Which is it? Did they just backdate this son of a bitch, or what? And then if they did file it on time, then why would the SEC the morning of the 17th say it will be publicly filed if they already filed it? If they did the thing, which is to file it, if they did the thing, which they filed it, then what do you mean it will be filed? Are you saying that the court files it for you, or are you the adult that filed it? It just, you see what I'm getting at here? It doesn't make any damn sense. Let's go through the rest of the analysis, though. So here's a post from attorney James Murphy, aka Meta Lawman, and he shared this. This is the relevant. This is actually, honestly, out of the whole 180 pages, this is the only relevant portion. The reason being, almost 100% of those pages out of the 180 pages it's just a copy of Judge Torres' ruling. So that's why it's so lengthy. But this is the only part that actually matters. And it reads as follows. This is from the SEC. Whether the district court erroneously granted partial summary judgment in favor of defendants with respect to Ripple's offers and sales of XRP on digital asset trading platforms, and Garlinghouse's and Larson's aiding and abetting of those offers and sales, Garlinghouse's and Larson's personal offers and sales of XRP, and Ripple's distributions of XRP in exchange for consideration other than cash. These issues are to be reviewed de novo. And I'll explain what de novo is in just a second, because I got something from attorney Jeremy Hogan, and he explains that. First, let me share with you what attorney James Murphy had to say. It reads as follows. Ripple appeal update. The SEC has filed the Form C a day late, in my view. The SEC, and folks, so again, just reiterate that. This is what I've seen from pretty much every attorney that the name of any attorney you've heard in the space, probably, this is the perspective. Yeah, it must be. And then they do kind of hedge a little bit. They're like, well, okay, in case there's something that we just don't know or we haven't thought of, which I think is fair enough. That's perfectly fine. But in terms of when's the actual due date, that's not in dispute. The due date, not disputed by anybody. It was October 16th. It's just a question of, did they file on time? Well, we're going to see. I don't technically know for sure, but, I told you my piece. I just, if you're taking what has been stated at face value, I don't see how they could have filed in time. But, if that comment from that Eleanor Tarrant got from the SEC, if that's not true, well, then all bets are off. If they worded something that isn't true, because again, they said will be filed. If that's not true, then what the hell? So anyway, attorney Murphy says, the SEC is appealing the summary judgment ruling on, number one, Ripple's XRP sales through exchanges, and number two, Ripple's distribution of XRP to employees and others, and three, Garlinghouse and Larson's sales of XRP on exchanges. He says, this is what we expected. Mildly surprising that they did not appeal the $0 ruling on disgorgement. Yeah, so actually, and that's fine if he expected that. I was a little surprised by a couple things. The biggest thing, I suppose, setting aside the date fiasco, would be the fact that Garlinghouse and Larson are named in this. I didn't even know that was a possibility since their cases were literally dismissed by the SEC. It was just thrown out. And then I was also a little surprised that they didn't go for disgorgement. I thought that they'd overreach there, or at least there's a good chance. So it's not like wildly surprising that they didn't go for that, but if I had to guess, I would have said, yeah, they'll probably go for that as well. The thing that I felt most confident, though, is that they'd go after Ripple's programmatic sales of XRP, which they certainly have. The good news is that doesn't impact regular XRP holders, buyers, and sellers like you and I. It has specifically to do with Ripple sales. Here is what Stuart Alder already had to say. He is, of course, Ripple's chief legal officer. He says, no surprises here. Once again, it's been made clear. The court's ruling that XRP is not a security is not being appealed. That decision stands as the law of the land. Stay tuned for Ripple's Form C to be filed next week. Yeah, so sleep easy. And the market's not freaking out about this either. I'm not pulling up prices for the sake of this video, but market doesn't give a damn. Everything's fine. The market accepts that. There's absolutely no problem. But yeah, XRP itself, not a security. That's not being challenged. I just showed you what the SEC is actually appealing. That's all the surface level claims effectively, and they'll make more thought out arguments in the future, of course, which I'll run through with you when we get to that point. But that's it. There's nothing about XRP itself being a security, which has to be expected. They can't. They literally can't, because it was just dicta from Judge Torres anyway. Here's the post from attorney Jeremy Hogan. He says, I've never been so excited to get a C since I was in high school math. What is not being appealed, that XRP is not a security. What is being appealed? Ripple's sales of XRP on exchanges and the use of XRP as a kind of payment. What does de novo mean? It means the appellate court is ruling on a pure issue of law and doesn't have to defer to the trial court on the law issues. What I don't like? The SEC completely folded when it had the opportunity to actually try the case against Garlinghouse and Larson in front of a jury. And now it's trying to bring those claims back to life. Chicken move, in my opinion. What I like? This appeal is about money. The injunction could change if Ripple were to lose, but only indirectly as to order compliance. Okay, and so when he says that this is about money, I'm still actually slightly confused, to be honest, because obviously, as I just shared with you, as far as disgorgement, this and that, nothing else was cited there. So if he's saying that specifically because there would be monetary implications based on what would happen if the SEC got a positive ruling in programmatic sales, well, then that would make sense. So I'm almost certain that's what he's referencing, because what else could it be, right? So that seems like a virtual certainty. I just thought I'd mention, just kind of thinking out loud here. Then there was also this. Somebody asked him, Attorney Hogan, when they appeal the sales of XRP on exchanges, doesn't that indirectly mean that they appeal that XRP is a security? And Attorney Hogan reiterated, he said, only as to Ripple, so that's a no. It's not about XRP. And then he clarifies further. Even with an adverse ruling, each sale of XRP by Ripple would still have to qualify as an investment contract. So it will never be a security like a share of IBM stock is. So there you go. As far as us as regular, everyday XRP holders, nothing to be scared about in that regard. Here's a post from attorney Fred Rispy. He says, the Second Circuit is the big boys league, and the SEC cannot afford to clown around like it has been at the district court level. It wisely recognized disgorgement was a loser argument, even though it argued that with Torres, and has not raised it as an appellate issue. So that's interesting that even the SEC is like, well, with the big boys league, maybe best not to bring that one. That's what Attorney Rispy is thinking. Very well may be the case. Here's a post from John Deaton's crypto law organization. Why was this filed a day late and backdated by the SEC? Was there internal disagreement on how this single paragraph, the only relevant part of Form C, would be worded? Yeah, and so I'm still wondering this. I just don't see how reasonably they could have possibly filed this on time and then it gets out a day. It just doesn't make any damn sense. And again, I'll say one more time, for sure, the deadline, we know this for sure now, it was October 16th, 11:59 p.m. Eastern time. We know that for sure. But did they actually file it by then? And then what? I mean, outside of some sort of technical glitch, but that's just odd. And so then the technical glitch, it just happened to occur right near the deadline. That's a lot of weird coincidences to me. It just happened to be that close, and it's never happened before, but it happened to occur this one time. I mean, if that's the answer, then okay, but I'm skeptical of that at this point. We'll see here. And so there's also a post where I was asking about, okay, what's going on with this? You know, the fact that, Brad and Chris, Brad Garlinghouse, Chris Larson, their charges were dropped, but now they're being named here in Form C with this appeal situation. What's going on? And so XRP community member Sherry was kind enough to respond, and she wrote, the stipulation was on the premise that Garlinghouse and Larson's sales were programmatic ones, which the judge deemed to not be securities. If Judge Torres gets overturned, then those two are automatically in trouble. Now, okay, so I actually have an additional question on that. I thought about it more, and I appreciate that because I didn't realize that this was even a possibility, like a thing that could happen. So I was definitely caught off guard, but I hadn't seen anybody talk about this. But, programmatic sales, programmatic, that's a term that Ripple created to describe just their sales of XRP on secondary markets, basically. But again, it's sales that Ripple initiates. I don't know how they can then say that term, which Ripple created, which they only set to apply specifically to Ripple, the company, could also then apply to Brad Garlinghouse and Chris Larson. So if the SEC is allowed to do this, and I mean, if they are, then I'm going to yield to the lawyers. I'm not an attorney here. I just play one on YouTube. I just don't know how that is, because those have never been described as programmatic sales. Like, nor would it be for any individual human. Like, if I sell XRP on Coinbase, that's not a programmatic sale. That's just a word that Ripple decided to use to describe the company sales, like I said. So if I sell, that's not a programmatic sale. So then if Brad Garlinghouse sells and it's outside of the context of Ripple, the company, how is that a programmatic sale? So maybe there's a good answer for that, and there's something I don't know. I don't pretend to have all of the answers here, so I'm just sharing with you what my thought process has been to this point. So I'm going to try and dig into that one a little bit further. Maybe there's a good answer, or maybe there's not, and the SEC's overreaching here. I'm not quite certain just yet. Then there was also this post. So this is another one from attorney James Murphy, aka Meta Lawman. And so he wrote, "This is weird. The SEC's Form C is dated October 16th. The court's file stamp on the document is October 17th. We should find out soon whether the Second Circuit concludes that the SEC has missed the deadline." And so there you go. He said in a previous post, and it makes sense, this is not a critique, again, I'm just repeating what he stated, which is that in his view, this thing was filed late. And then in this post, he's saying, well, we're going to find out. Basically, we're going to find out if they filed late. And again, I just don't see how they didn't file late. Outside of some sort of bizarre technical glitch, which just so happened to be at the moment in time where they would have needed to file last minute. What a coincidence then. That would just be freaking bizarre if that's the case. If it is, though, okay, fine. That's just, it's wacky. Now, former SEC attorney Mark Fagel did respond, and he wrote the following. "I'm not an appellate guy, but is it possible there is a docketing time lag? The filing shows the SEC pulled the district court docket early Wednesday morning. Kind of a weird thing to do if they weren't planning to file it Wednesday." Okay, and so certainly fair enough point here. But look, and I don't have firsthand experience with this, but from what I've seen from attorneys when they post anything that has to do with, over the last several years, that's had to do with the SEC v. Ripple case, something gets posted and then they have access to it, snap of a finger, immediately, right away. So if that's not the case here, and there is a time lag, and that's normal, even these attorneys who are seasoned have never heard of such a thing. That's also interesting to me. So attorney Meta Lawman, attorney James Murphy, responded, and this is why I'm so skeptical of this delay theory. An electronic delay, really? Check this out. He wrote, "Mark, I really don't know. The whole point of the innovation of the electronic filing system was that you get an instant filing when you push the file button from the comfort of your law firm. This scenario is puzzling to me. Exactly. This isn't snail mail. It's not like you submit it and then your electronic transmission is somehow physically carried by a pigeon to some sort of physical location where it's then uploaded to the Webernets. Like that's not how this works. So it's very peculiar either way. I don't know what's happening. Could it be that the SEC, maybe they had an intention of filing, and that's why Attorney Mark Fagel's seen this date of October 16th, and then they really did make a mistake and really did forget to file. Maybe they had one too many at happy hour, and then they forgot to get back to it, and that's where like, oh crap, I didn't file the thing, even though I pulled it on the, you see, look on page, there's the transaction receipt, oh, but I didn't file it, and then they're like, wake up with the hangover the next day rather, and they're just like, oh, that's a problem for us. I don't know. All I'm saying is, it's weird. No matter what the answer is, it's weird. None of this makes sense. And also, here was Attorney Bill Morgan's response to this. Backdated question mark? And so, I mean, I think that's the default thing that most people are thinking. Once they see, wait, October 16th, but the electronic date is the 17th? Well, he's asking, well, maybe it's backdated then. Right. And that's what I see, that was the default assumption from pretty much everyone. And I think for good reason. That's a pretty damn good assumption, right? Even if we don't technically know for sure at this point. Here's a post from Fox Business journalist Eleanor Terich. She said, and yes, I see there are two different dates here on the Form C. I have reached out to the SEC for comment on this. Nothing that in the comments... noting that in the comment the SEC sent me this morning, they said the docs will be filed publicly soon. Were they filed last night and didn't appear on the docket until today? We'll find out. And so she is looking to get an answer. As soon as I know, you will know, because I will update you with via video promptly on this, as quickly as I can anyway. So I don't know. But again, there's a reason I started talking about what I talked about in this video first. You could argue it's semantics, but it matters. If you take what the SEC said at face value, it means that they did not file that document on time. If you take it at face value, unless you're saying that they don't count as the filer, even though they're one of the filers, which is, again, it sounds completely absurd, but that's the only way that you could try and logic yourself out of this dilemma. So I don't know. They're going to have to answer though. Like, this one's not just going to go away. Like, we are going to find out. And in fact, if indeed this was late, the court's going to have to address this, obviously, because they're past the deadline. The court's going to have something to say, even if they allow an exception, which, frankly, I'm willing to bet they would do. That would just be my for fun guess. They'd still need to have some sort of explanation that would be public, obviously. So we'll see. And then I also posted the following. Was this definitely electronically filed by the SEC today? Or is it technically possible that the SEC could have submitted a physical copy yesterday on time, which wasn't uploaded to the internet until today? Okay, and so somebody in the community, I don't remember the name, somebody posited that idea, so I just thought I'd ask, and I tagged some attorneys. I got a couple of responses here. But could they have actually just pretended like it's frickin' 1985 and gotten in their vehicle, driven to wherever the hell they have to file this thing, and then did it in person? Did they actually do that like it's 40 years ago, before the internet? And why? And then why have they never done this before? Because they've always done these electronic filings before. Attorney Mark Fagel, former SEC attorney, says the following. Either is possible. The document is dated yesterday and includes the docket sheet obtained yesterday morning, so it makes no sense they held it until today. It's ultimately totally irrelevant, a minor document where nobody was prejudiced, only interesting in crypto Twitter. Well, so that goes back to what I was saying, though. Since it was dated yesterday, that's what I'm saying. Maybe they had every intention, and then they really did just forget. Maybe they really did. Why? It's so irresponsible to wait till the last day anyway. Even if they did, like, why are you doing that? Why are you playing that game? I mean, if you're really that freaking slammed, but I have trouble believing that, like, because this is consistently what the SEC does. They wait literally to the last day, sometimes like the last hour. You're playing chicken. Like, what are you doing here? That seems unnecessarily risky. Are you so slammed with all of your work that it has to be like that every single freaking time? I mean, if so, okay. I find that hard to believe, though. Sherry, XRP community member, also answered that question for me. And she said, I do not believe the SEC ever presented a physical copy since there had been a login to Pacer. Unfortunately, we are going to have to wait on the mystery to be solved. I'm very curious how this late filing could have happened. Yeah, equally curious, Sherry, for sure. And that's a very good point. And so just to be clear, I never thought that there was like even a remote chance that the SEC would have physically filed this thing. I was just trying to rule everything out. I understand technically they could have, but if they did that, which I think is about a 0% chance anyway, well, why'd they log into the Pacer, to Pacer here? As you can see, there's the Pacer Service Center, transaction sheets on your screen there. Why'd they log into that if they were just going to pretend like it's 1985 and hop in a car and just drive down there? That doesn't make sense either. So either my best guess is either it's an actual honest-to-God technical glitch that caused a delay at a very coincidentally interesting time. It just happened to be at the time where you would have expected this to be filed. Either that's the case, or they had every intention of filing on time and they actually forgot. I'm guessing it's one of those two. Maybe we'll find out for sure. I mean, we're going to find out something. We're going to find out for sure whether it was late or not. But as far as the rationale behind, like the reasons behind it, well, we'll see how much truth ever comes out. But we are going to know if this was filed late because the court is absolutely going to have to address that if indeed it was filed past the deadline. And if it wasn't, then if it's never brought up, then there's your answer that way too. So we will find that out. I have 100% confidence in that. But that's where we're at, folks. See how convoluted and ridiculous this is? But look, bottom line, other than that, the good news is, again, XRP totally got legal clarity. And then on top of that, another key takeaway, this crap with Brad and Chris seems totally unreasonable and unfair, but the SEC, they're full of a bunch of asshat pricks, so nobody's surprised that they're being as awful humans as they could possibly be. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.